Dale committed malice aforethought in the split second it took her to command her wolf dog to attack Brian Hamilton. And even if you believe that Miss Peak did not give an attack command, she committed malice aforethought when she allowed her dog to continue attacking Brian over 3 minutes, while she stood on her porch smiling. The 911 transcript shows that the attack lasted several minutes before Peak called her wolf dog off. A quicker response more likely would have saved Brian's life, perhaps leaving him only disfigured from the encounter with the dangerous wolf dog. Members of the jury, the state requests that you return a verdict of guilty on the charges of murder and possession of a dangerous animal. Thank you.
Does the defense have closing statements?
Yes, Your Honor.
All right, Ms. Bennett.
From the beginning of her life in the States, Mrs. Peak has never been accepted by her neighbors or people in general, and she has never known why. When Briarcliff Junior High School first opened, the teenagers that came to reside in Briarcliff Avenue began pranking and hassling Mrs. Peak's home. It was when Mrs. Peak would call to report these incidents that Officer Terry Culbertson suggested, under his expert opinion, that she should purchase a guard dog. My client did the absolute right thing and contacted a certified guard dog trainer. She contacted Leslie Harris, who is a certified guard dog trainer for Great Danes, Shepherds, and Lupo Hounds. Miss Harris believed that the Lupo Hound and the other dogs that she specifically works with are satisfactory guard dogs, but she specifically believed that the Lupo Hound would satisfy Mrs. Peak's needs. Not only did Mrs. Peak want protection, she wanted a friend. She had lived the majority of her life alone, and now she came to the States to live a peaceful life during her retirement. And now, with everyone pranking her and not relating at all, she just wanted a companion. And what would be better than a dog? May I remind you that Pat Demura specifically says that the Lupo Hound was bred to be an independent and fearless dog, which would make sense why he would have acted of his own accord and seen Brian Hamilton attempt harm on his master. He believed, under his training, that he should attack. If someone is trying to attack his master, that's what his training taught him to do. In the South Carolina Code of Laws, section 473710, under the subject dangerous animal, it specifically says that we cannot characterize a canine or feline as a dangerous animal by breed, virtue, or species. The only time we can ever classify a feline or canine as a dangerous animal is when they have attacked and it was unprovoked. And we know that Zeus's attack was provoked. Brian Hamilton knew there was a guard dog inside Mrs. Peak's home. He knew there was a Lupo Hound inside there. He knew all the circumstances that could come from him tossing a tennis ball. And yet he still tossed it. May I remind you that Chris Holliday is the only witness we have present today in court that was at the accident, and he is known to have committed a felony. Not only do we know he committed a felony, we know that he was one of the accomplices in pranks on Mrs. Peak's home. The evidence is in the police report and his testimony. The pranks he mentioned in his testimony correspond with the police report, so we must conclude that he must have been involved. I conclude today that my client never intended for Zeus to cause harm in any way. She simply wanted protection and a friend. For a moment, I would like you to place yourself in Mrs. Peak's position. Would you not have done the same? Would you not have believed that a police officer who has had as much experience as Officer Terry Culbertson has would know what he was talking about? Would you not think that a certified guard dog trainer for the specific dog that you purchased would know what she was talking about? My client simply did what Officer Terry Culbertson and Leslie Harris suggested she do. Thank you.
All right. Ladies and gentlemen of the jury, that concludes all the evidence in the case, as well as the closing statements from the attorneys. Normally at this point I would instruct you as to the law and also instruct you as to the standard of proof in this matter, which I will briefly do. I'm not going to read to you the South Carolina statutes that have been provided to me. However, I'm going to give you a copy of those statutes that you can take with you into the jury room and refer to them in your deliberations. Based on what's been presented, it appears that the defendant has been charged with the offense of murder as well as harboring a vicious animal, and those statutes are provided to you here, along with statutes for manslaughter and involuntary manslaughter, which could be lesser included offenses in this matter. I will give those to you to take with you in your deliberations just in a moment. I would remind you that this is a criminal matter, and the burden of proof in a matter such as this is upon the state to prove each and every element of the charges against the defendant beyond a reasonable doubt. And you should consider that in your deliberations. With that said, if you will go with the bailiff, he will accompany you to the jury room. I don't know if I have a written verdict form. One was not provided to me, but you can just pick a foreman and then have that foreman handwrite your verdict form as to what your verdict is. When you have reached a verdict, if you will knock on the door and advise the bailiff of that, he will come and advise the court, and will have you come back out and report your verdict to the court. There were several exhibits entered in the case, I think 7 total, and we will have those gathered up and brought back to you along with the copy of the written legal instructions. So with that, if you will go with Mr. Miller, do you have all the exhibits? It should be 7. And normally there wouldn't be any highlights on these. Well, I'll have him make a clean copy of this because I had highlighted some of the law stuff, and I don't want to influence him with what I read. So, if you'll go with Mr. Miller, and Eric, if you'll try to make a clean copy of the law, and we'll stay back there with you. All right. So, good job. So,
Any feedback, immediate feedback from you, would be appreciated?
all right. There were a couple things I was gonna point out to you. I mean, normally I know you're not. What you guys are 7th or 8th graders? Okay, that's what I thought. Just a couple of things that came to mind when we were going through it. With regard particularly to the exhibits, you all obviously are not trained lawyers and don't have training in terms of how to properly introduce exhibits. And but I would tell you, if you would move forward and become lawyers, that you do it a little differently than we did it during the trial. But since there were no objections, I just started going ahead and doing it that way. Normally, when you want to introduce an exhibit, you would identify the exhibit, you come forward, you show it to the witness so that that witness can lay a foundation for that exhibit, and then it goes forward from there in terms of introduction of it, instead of just saying I have this and can I admit it. But given the fact that there was no objection, I just went ahead and let those things be admitted. Also, some of the things that were admitted, like there was an article in particular that I think was out of a magazine or a book or treatise of some sort, that one of the experts testified about. In a real trial, an expert can rely on anything, even if it's hearsay. So you could show him that article, he could talk about that article, he could probably sit there and read the article, but I'm not sure that I'm not sure you would have been able to lay the foundation to get that in if this had been a real trial. Another thing that happened was when one of the witnesses was on the stand, somebody cross-examined him about having a prior incident of stealing, and normally things like that are not admissible unless they're, a crime of some type of false swearing, or if it's a felony, and they have to be convictions, and there wasn't any evidence at all whether that person was convicted of anything or not. So that was something that we would, in a real trial, we would do a little differently. But one thing that, I was just kind of lulled to sleep myself. I actually made a mistake myself during the case, and that was when the defendant came up and she started to testify, and I just let you go ahead and start asking her questions. Does anybody know what I did wrong? Huh?
Plea?
No, I did. It's not. That wasn't it. It's not that I didn't ask her for a plea. You know?
The defendant has the right to remain silent.
Right. She has the right to remain silent in this case, and she has the right not to testify and not to take the risk of self-incriminating herself in the case. So if it was a real jury trial and we were really trying this case, when she took the stand, I would have asked her if she'd gone over her rights in that regard with her counsel and been advised of the fact that she understands she has a right not to testify and she can choose not to testify, and that if she does testify, she's subjecting herself to cross-examination from the other side, and I didn't do that. And I should have done that. The other thing that we, again, this is just a scripted trial, I know that, but normally, because you have the burden of proof in a case like this as the prosecution, normally you would reserve some of your closing time until after they speak, because you would get up there and lay out your case in your first closing, and then they would tell their side of the story, and then you would have the opportunity to rebut some of the things that they said in their closing. But of course, it's a mock trial, so you don't have the benefit of that. So, what does anybody think? All right. So what do you all think about how the case ought to turn out? I know what you guys probably think you should win, and you think you should win. And that's what I would think too. What does anybody in the back want to say what they... First of all, do you all have any questions about anything procedurally, trial-wise, that sort of thing? There were some things I thought you both did pretty well. From the defense's perspective, I thought one of the things that they did pretty well is they moved around the courtroom a little bit and examined witnesses from different places in the courtroom, as opposed to just kind of standing in one place. Back when I was a trial lawyer and was regularly trying cases, I would normally, when I was direct examining a witness, I would like to stand over there in the corner when I was talking, not all the way in the corner, but on the other side of the jury box when I was asking questions of my own witness, because I wanted my witness to be looking across the jury box at the jury, so that they would see the witness and establish some rapport with the witness. And usually, and I've seen other lawyers do that too. And then when I was cross-examining, I would like to stand up here where Mr. Nash was like to stand, because I wanted the witness looking at me instead of looking at them, so that they would pay more attention to me than to him. And, I've seen other lawyers do that too. And another thing that lawyers typically do, and of course you probably already even know the jurors, so that's a little different. But usually a trial lasts 2 or 3 or 4 days, however long, sometimes a week or 2. And usually at the beginning you're a little more standoffish, in terms of you don't want to get right in the jury's face. But then by the time of the closing, hopefully you've established a pretty good rapport with them, and a lot of times you want to try to stand a little closer to the jury box because you want them to relate to you personally. I didn't see a whole lot, and I think it's probably just the script. There wasn't a whole lot going on in this case about cross-examining the witnesses for credibility, except for the one guy who did get cross-examined about being a thief, which I think was an attempt to show that he was not honest. But usually, if you can show that the other side's lying about anything, and usually it doesn't even have to be something material to the case. 9 times out of 10, I think you'll probably win that case, because I think everything comes down to credibility. And if the jury doesn't believe one thing, a lot of times they won't believe anything else. So, Eric, did you want to say something?
Yeah, I was just curious. I noticed, and I don't know if you all remember, but before you did your opening statements, and again before you called witnesses, in your closing statement, he asked if you had any motions. You all looked a little confused and were a little hesitant on your answers. Do you understand what he was asking you and what that process is and what those could possibly entail? If not, ask. Don't be shy.
No, we didn't go through that.
Okay, well, I'll give you a very, very brief, and then the judge can obviously expand. In a situation like this, a lot of times, like those exhibits that you want to present into evidence, the defense could have potentially had a motion to suppress that and not allow you to put that in front of the jury. That's something that you might have presented before you came up and tried to get it in front of the jury, and that would be a motion to suppress the evidence. So there are different things you can do before every step in the trial that might kind of change what happens, or how everything turns out. So the judge might be able to expand on what that process is and what the motions are.
That would be what we would do before the trial starts. Now, by the way, this is my law clerk, Eric Johnson. I didn't introduce him earlier. Sorry about that. But during the trial, though, at the close of your case, you could have moved. It wouldn't have been granted in this case, and it rarely ever is. It's usually just done to protect the record. But you could have moved for a judgment of acquittal, because you could have taken the position that, Judge, they just didn't put on even enough evidence to meet any of the elements of anything to convict Mrs. P of this crime, so we ought to just win automatically. And every now and then that actually works, because every now and then somebody doesn't put on enough of a case to really get anything. That would happen more normally in a civil case than a criminal case, but sometimes it happens. In a civil case, you call that a motion for directed verdict. And at the end of the case, you could also make those same kinds of motions again, and that's what I was kind of getting at. But I wasn't surprised there weren't any of those motions, because I didn't think it was part of your packet. But this is a new packet from the last time you all were here, and I didn't get a copy. Last time I used to get a copy of the dialogue and kind of the script of what you were doing, and I didn't have that this time, and which is more typical of what would happen in a real trial, because a lot of times I have no idea what any of the witnesses are going to say, because I haven't had the benefit of reading their prior statements or that kind of thing. All I know is this person is charged with what's in the indictment, and I know what happened at a suppression hearing if we had one. So I don't know those things. So do you have any questions at all? Surely somebody's got a question about something. What do the folks in the back think? Do you think that this person's going to get convicted of something or not? Raise your hands if you think that it is a conviction.
It is?
that the person gets convicted. Okay, so far and away the majority thinks it's an acquittal. Why would you think that?
Because that's their side.
Okay.
Your opinion on and how West Virginia is different with the possession of a deadly animal or a vicious animal. Does West Virginia have a different law that they stated at the end than South Carolina?
To be honest, I didn't read the statute as super closely, so without actually going back and reading our statute and comparing the two, I'm off the cuff. I'm not really sure.
So was it that it was only considered dangerous
It's only considered dangerous when the attack is unprovoked.
when the attack was unprovoked?
Okay.
Have you ever had
no.
heard of a? Okay.
No. In West Virginia, I have to pull the statute,
Yeah.
but basically, this is a dog that didn't have any prior history, as far as I know, of biting anyone in this case.
Right.
So, I mean, under our statute, it almost gives the dog a free first bite to some extent. But I really saw, in this particular case, I saw it a lot different apparently than the people in this room. I wasn't going to let that slip until after the jury came back, but based on what my reading of the South Carolina statutes and what I heard in the courtroom here, I would have convicted this person not only of having a dangerous animal, but also of murder under the statute. And the reason for that is I thought there was pretty credible, unrefuted evidence that that the lady commanded the dog to attack, and it attacked. She commanded it to stop, and it stopped. And just bouncing a ball, I didn't think was provocation enough to justify what the dog did, and especially under the evidence that was given in the case as to the trained behavior of that dog. And it wasn't part of the packet, although it did come up a little bit at the trial here, when it was talked about those commands being given in foreign language, and there was consistent evidence that Mrs. P kept speaking in a foreign language. And I'm just, of course, I would be just like any juror who you would get in the box over there. You don't check your prior knowledge or your common sense or all that stuff at the door when you come in. And one of the things that I know from having been around police dogs before is they're almost always trained in German. And I don't know if that's German or not, but that was spoken in this case. But I do know that they train them in a foreign language on purpose, because you don't want somebody with a guard dog walking down the street and somebody yell attack, or, in English, and the dogs start attacking people. So I thought there was enough there to convict. So we'll see what the jury thinks.
Yeah, last year you sided with the what?
Last year I sided with the defense and the prosecution won.
No, you sided with the prosecution and the jury decided with the defense.
And the jury acquitted. That's yeah.
And so it's been an ongoing argument with that class. That the judge matters more.
Well,
We'll go with that.
you've gone, I think you've done that other packet twice. And,
Yes.
and one time the jury was consistent with what I thought, and
Right.
the next time they were the opposite of what I thought. But I really don't think, not to relitigate that packet, but I don't think there was enough to convict on that one.
Yeah,
So, but the jury last year did.
yeah.
I think Mr. Bennett and the lady back there with
Lori
the long hair
Greathouse.
might have been the jury last time.
Yeah.